And so my first question to this panel is, what is the single worst thing about the way we pick judges in the United States? And I'll start with Justice O'Connor.
Well, that's easy. It's the partisan election of judges in many of the states in the United States. We didn't start out that way. When the framers of the Constitution got busy, they set up a selection process for federal judges that involved nomination by the president and confirmation by the U.S. Senate. At that time, the colonies under Great Britain had judges appointed by the king. And as they gained independence as colonies and states, they initially had appointive systems for their judges, much as the system devised by the framers for the federal judges. But later on, the idea of electing state court judges started to take hold in the states, and it pretty much swept through the country. A majority of the states today still have some form of election of their judges. No other nation around the world does that, so it's a very unusual system. Now, when there are partisan elections of judges, a lot of money changes hands, and I think cash in the courtrooms is a very bad idea.
Judge Kaye?
In preparing to come out here today, I discovered a fact I'm not particularly proud of, as long as Justice O'Connor has begun with the history, and that's a good place to start. I think we all have the state of New York to thank for the fact that partisan elections took hold around the country. We began with our People's Constitution in New York State in the year 1846, and it was a revolt of the tenants against the feudal system. That's really where it all got started. We adopted partisan elections in the Constitution of 1846, and the other states looked around and said, well, if New York is doing it, it can't be all that bad. And so many of them followed suit too. And that's how we got it. I have to agree with Justice O'Connor that the partisanship, the politics, capital P politics, the money, the campaign rhetoric, the special interests are certainly the most corrosive of all things in terms of public confidence in the judiciary, which is really what we so sorely need to have in the selection process. We need to have the very best judges. We need to have the very best selection process. When you consider the issues that come before the courts today, we really want to know that we have a sound judiciary, good people making these really important decisions. We want that in fact, and we want the public to believe that in fact, that the decisions are based on the law and not on contributions and party politics.
Professor Carter?
Well, I certainly would agree with the two distinguished jurists on my left that there are a lot of problems with the way we select state court judges, and the money involved may be primary among them. But I actually think the worst thing about the way we select judges today is in the federal system and its confirmation hearings. And I'm willing to stake out a very radical but traditional position. I don't think there should be any confirmation hearings. For the first 150 years of the Republic, there were no confirmation hearings because it was widely agreed by everyone, literally everyone, that to make a nominee for a judgeship, or worst of all, the Supreme Court, sit before the Senate and answer questions was an impermissible interference with the internal affairs of that branch. In the oft-quoted words of Abraham Lincoln upon his nomination of Salmon P. Chase, his political rival, to be Chief Justice of the United States, he said, "We cannot ask a man what he would do," meaning what he would do as a justice, "and if we should ask him and he should tell us, we should despise him for it." The reason we have confirmation hearings in the United States is because of Brown against Board of Education. Brown was decided in 1954, holding that school desegregation was unconstitutional. The following year, the Senate, which at that time was run largely by the Southern Democratic Party, the Dixiecrats, who wanted to preserve segregation, decreed that henceforth, they adopted a special rule, all judicial nominees would come and sit before the Judiciary Committee. At the time, this was greeted with outrage on the left. It was considered a terrible thing to imagine that nominees should do this, and the consistent position, what was considered the liberal position, I think still the correct one, from the 1950s through the middle of the Nixon administration, was that these hearings are inappropriate and that certainly we should ask no questions meant to work out how people would vote. I think that was the correct position, and I think that we do enormous damage to confidence in the judiciary when presidential candidates of both parties tell us that they're going to pick for the courts people who have made up their mind in advance on important issues of the day. And we as voters fall into the same trap, betraying our lack of confidence in the courts when we say we want a president who will select the kind of judges we want, as though we think justices should be amenable to the popular will. Though what really matters is not their considered reading of the Constitution and the statutes, but rather our judgment as a majority. I think that's not the way to run a court. I think the way that we select judges, or more to the point, where we talk about the selection of judges, does enormous damage to public confidence in the courts.
Okay.
Oh, I agree with both Justice O'Connor, with whom I always agree, and
But she doesn't always agree with you.
well, I always agree with Justice O'Connor, but she makes up her own mind. But I also agree with Professor Carter. The state court system, there are 39 states, I think you said,
39, right.
that have some form of judicial election process. They're not all partisan, and some of them aren't as bad as some of the others. But the ones where there are partisan races for, especially the courts where they decide decisions that are extremely important to either the trial bar or industry or employers or whatever particular special interest group that you can think of, and the influence of money has just been overpowering. The statistics that have come out, and you mentioned some of them, are just frightening. I filed, this is an example that I think is one of the most recent. I filed a cert petition in the Supreme Court today asking the court to take a case from the West Virginia Supreme Court. We asked the court to take that case because it was a dispute between two coal companies, and there was a $50 million verdict or judgment in a case against one of the companies. The case was brought up on appeal. The West Virginia Supreme Court, on a 3-2 vote, reversed the trial court $50 million trial court decision. Shortly after that decision came down, but before it was actually final, pictures were published in the newspapers in West Virginia showing the Chief Justice of West Virginia on the Riviera with the president of the company he had just ruled in favor of. And of course, there were companions in those pictures. And so there was a movement to ask the court to set aside its decision, grant a rehearing, and for the Chief Justice to recuse himself, to disqualify himself from participation in the case. Well, he did, and one other justice did, and the justice who replaced him as Chief Justice turned out to have been a person that had received more than $3 million from that same president of that same coal company in the most recent election that was taking place while this appeal was pending, that was over 60% of the money that individual had received in his re-election campaign. 3 out of the $5 million, plus another $800,000 had been raised. The people that raised the money published ads on television attacking the justice that was being replaced as someone who would free child molesters and would turn child molesters loose on the state of Virginia. It was that kind of advertising that this money financed. We're asking the court to say that there's got to be some lines where judges have to recuse themselves. Otherwise, people are not getting a judicial process that accords with the Due Process Clause, a fair and independent judiciary, a judicial determination by someone who doesn't have a financial interest or where there's a strong appearance of impropriety in the system.